Thank you for dressing purpley for court. So let me see. All right, so discovery, was that completed?
Yes, Your Honor.
All right, and today is the plea deadline date. So is this going to be a jury trial or have you all reached an agreement?
We have reached an agreement, Judge.
Hold on, big moment here. No jury trial means the defendant just escaped the drama of 12 strangers deciding his fate. But there's a twist: plea deals are risky. The judge doesn't have to accept them. So, is this a lucky break, or the calm before heartbreak?
I should explain to the court.
Yes.
We're in agreement with all the terms. It's been a written plea agreement. We've gone over it with Mr. Lunsford, and we do have an agreement. One of the things that the state wants to accomplish prior to the plea is restitution up front. The state, and I don't want to speak for them, but my understanding is they need a little time not only to identify the specific recipients of the restitution by name, addresses, who the check should be made out to, and the amount. It's a substantial amount of money, and we are able to pay that before sentencing. So I would suggest perhaps 30 days to get those numbers done so that we can present the agreement to the court.
Let me make a suggestion. I would suggest that you all do the plea today, and I will set it in 30 days for sentencing. And then if for some reason and it will be set for a restitution hearing before the sentence.
Notice what the judge is doing, pushing for the plea today, not later. That's not just efficiency, that's strategy. Once the plea is locked in, everything changes. The balance of power shifts. So, who's really in control now, the defense or the prosecution?
And if there's an objection to the restitution, if there's an issue with the restitution, we can handle it then.
I have no, part of the plea bargain is that it would be paid up front. So as long as the first sentence is imposed,
yes,
then that'd be acceptable to the state.
All right.
Yes.
So then that way, once I'll take the plea today, the sentencing would not occur today. And I'm assuming there's no need for a PSI or TAP evaluation, or is there a need for that?
I think there is, Judge, because some of the terms and conditions, there are going to be things left up to the court's discretion.
All right. Well, what I can tell you is, sorry to interrupt, but what I can tell you is just to cut through things, a PSI is going to take 8 to 12 weeks. So we can enter the plea today, and then it'll be 8 to 12 weeks. That'll give everybody plenty of chances to get the restitution amount, and you all can confer off docket. Is that good for everyone?
That's fine with the state.
Yes.
All right, so if you guys will get the plea paperwork ready, I'll take the plea, and then we'll set it for a sentencing. What date would that be on, Ms. Ferguson? Well, no, it's going to be a PSI and TAP evaluation, because that will give you more time with a PSI and TAP.
Yes.
So it'll be October 20th. And what I can tell you is PSI and TAP, those are two completely different things. So they're going to be two completely different dates for you to see probation. So make sure you meet all of those dates.
Yes, ma'am.
So October 20th, is that good for everyone?
Judge, I have a federal trial that day, but I don't think it's going to go. If we're a couple of weeks out, that looks hard, then I'll come.
Okay. All right. So we'll set it for October 20th, and I'll wait for you all to do the plea paperwork. Once you've completed that, just let them know and we'll take it up.
Thank you, Judge.
All right. Thank you. Spurt, please. And Norma, I need a court date for PSI and TAP. October 20th? Okay. All right, court is going on the record. Court is calling 2025 CR 1023 State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
Dan Cogdill and Sam Locke.
And are you Mr. Lunsford?
Yes, sir.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsels, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as
Did you see that? The state just dropped more than 50 counts and is proceeding on a single charge, a huge shift. Going from 55 counts down to 1 looks like mercy on the surface, but it could also be strategic. Concentrate all the prosecutorial weight on the strongest allegation. That change completely transforms the stakes.
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
any objections?
No, ma'am.
Mr. Lunsford, did you review the document entitled, just one moment. Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with money laundering? Everyone, please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felon?
5 years minimum, up to life in prison. That's not justice, that's a sentence buffet no one wants a taste of. So tell me, would you risk it all at trial, or take the deal and live with it?
The punishment is anywhere from 5 to 99 years in life and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
We just got the defenses with it, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a United States citizen, by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into?
Here's the curveball most people overlook: immigration consequences. A plea deal isn't just about prison time, it can completely rewrite your life's map. One signature, one courtroom decision, and you might lose the right to ever set foot in the country again.
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 1. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions. Counsel, could you all check the box here and
Yes, sir.
initial? Did you understand that to be the plea?
Sure.
Defense, is that the plea?
With the caveat that the state was going to recommend probation. Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yeah, ma'am, you just, it's like,
Sorry.
you said, they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, Your Honor.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, Your Honor.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand?
Yes, Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course and MRT. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to count one, how do you plead? Guilty, not guilty, or no contest? I'm sorry?
No contest.
State any.
The classic no contest plea. It means, I'm not saying I did it, but I'm not fighting it either. Legally, it's nearly identical to pleading guilty, but it can protect you later in civil court. Clever strategy or just clever wording? You decide.
Offering State's Exhibit 1 and all attachments. And Your Honor, I would just want to clarify for the record that count 1 is first-degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you. I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than signs. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, there's a stamp over the discovery.
I saw that too, Judge, a postage stamp that made its way into the document. I wasn't sure what that was
So I'm not able to read that. If I lift it, it tears.
I can get another copy, Your Honor. It's going to take me a little while.
All right, no problem.
Okay.
This is why I took math in school. So, Mr. Lunsford, what's taking the court a while is that because this is submitted to me, I have to find that there's sufficient evidence to find you guilty. So I have to do my math to make sure this adds up. All right?
Second chair.
All right. After reviewing State's Exhibits 1 and attachments, the court will find there's.
And there it is, the hammer drops. The court decides there's enough evidence to move forward, but stops short of declaring guilt with deferred adjudication. In simple terms, the defendant isn't free, just walking on legal thin ice. October 20th marks the real judgment day.
To find you guilty, court will defer finding of guilt as you've applied for deferred adjudication. We'll come back here for sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record?
No.
All right. Once you sign the reset form and speak with probation, you'll be excused. All right. Thank you.
Thank you.
Thank